Hello, we're going to get started today with a presentation on OSHA liabilities. Welcome and thank you for joining me for today's installment of Bond's Manufacturing Week seminar series. My name is Steve Ricca. I'm a member of the statewide firm of Bond, Schoeneck King, and I have 30 years of experience representing clients in a host of regulatory compliance, health and safety, and administrative matters. A significant percentage of my practice focuses on representing manufacturing clients. Today, I hope to shed some light on how you can minimize OSHA liabilities, such as through an OSHA inspection by a compliance officer. The three topics that I'm going to cover today are responding to an inspection. I'm also going to discuss enforcement considerations, as well as new slip and fall rules that became in effect at the beginning of this year for walking, working surfaces, and fall protection. By way of background, OSHA has two primary functions. One is to set standards for workplace safety. Another major function is to conduct inspections to ensure that employers are providing safe and healthful workplaces. OSHA applies to private sector employers only. Public sector employers are covered through PESH. In 2016, OSHA conducted 31,948 inspections. The circumstances that led to the inspections included, in order of priority, imminent danger situations, severe injuries and illnesses, worker complaints, referrals of hazards from other agencies, targeted inspections, and follow-up inspections. The preliminary list of top 10 violations for 2017 include fall protection, hazard communication, scaffolding, respiratory protection, lockout, tagout, ladders, and we'll be getting into ladders later, ladders in the construction industry. I think there'll be a trend that you'll see more ladder-related citations in the general industry context. Powered industrial trucks, machine guarding, fall protection, and electrical wiring. Generally, enforcement's been on the rise. In the past several years, OSHA has seen budget increases, hired scores of additional compliance officers, and increased the number of inspections. This has resulted in more citations with higher penalties. However, we're obviously in an era where, from the presidential Trump administration perspective, there's been an emphasis on deregulation. This is embodied in a January 30, 2017 executive order by Donald Trump, in which he has advised all of his regulatory agencies, including OSHA, that for every new proposed regulation, that two be withdrawn. So the regulatory context in the OSHA setting is evolving. Based on a July 2017 regulatory agenda posted by OSHA, there's been a withdrawal and reclassification of numerous proposed federal regulations. In fact, there's been 469 proposed regulations withdrawn, and 391 other regulations have been reclassified. Examples of withdrawn regulations include those pertaining to bloodborne pathogens, combustible dust, presenting backover injuries and fatalities, styrene exposure, such as in the boat manufacturing and tub and shower manufacturing industry. Also withdrawn are updated requirements for hearing protection devices, and the list goes on and on. Regulations that have been reclassified and delayed, if you will, include those covering an update to the HAZCOM regulations, process safety management in the chemical industry, and emergency response and preparedness updates and requirements have been put on hold. Another development worth noting is the fact that Congress rescinded the Volks rule, which would have allowed OSHA to issue citations beyond 6 months for a failure to maintain records concerning injuries and illnesses. This is an area that continues to be evolved. There's a bill in Congress to reinstate the Volks rule, but the bottom line is things are in flux, but enforcement and inspections continue to be a priority from OSHA's perspective. Not affected by any of this regulatory uncertainty, by the way, are the slip and fall requirements that I'll be discussing in today's presentation later. As I said, OSHA penalties can be severe, and they've been recently increased as of August of 2016. As you can see from the chart, it used to be that the maximum civil penalty for the specified types of violations, serious, other than serious, and posting was $7,000 per violation. It is now $12,471 per violation. Likewise, the failure to abate has experienced a similar increase. Most importantly, willful or repeated violations can now subject a company to a civil penalty of up to $124,709 per violation. And we're going to get into this a little bit later in today's presentation. The fact that a willful or repeated violation carries such a huge exposure, it really plays into how you want to deal with a citation that you may receive from OSHA and whether to contest it. Serious violations, by the way, are those that are considered to have a substantial probability of death or serious physical harm. Other than serious, concern violations that the likely injury or illness associated with the violation probably wouldn't result in death or serious physical harm. Willful or repeated violations, the most serious ones. Willful refers to an intentional disregard for OSHA regulations or indifference to the regulations pertaining to environmental health and safety. The penalty factors generally consist of the gravity of a violation, whether you're acting in good faith, the size of your business in terms of net worth and related issues, and whether you have a history of previous violations. I'm not going to delve too much into that. That could be the subject of a whole separate extensive discussion. In terms of recent enforcement activity, as you can see, some pretty big numbers posted for an auto parts supplier in Michigan. The big numbers are largely attributable to willful and repeat violations. A muffler component manufacturer in Green Bay, Wisconsin, Concrete Corporation in New Jersey. These are all numbers that are a significant cost of doing business and therefore require careful attention to avoid them. I recently had a joint enforcement last year for a chemical manufacturing client that was a joint process safety management enforcement action under OSHA and an EPA enforcement action under the risk management planning requirements of the Clean Air Act. The combined total negotiated penalty in that case, and the negotiation started at $974,000, was $124,000 with some abatement costs and other supplemental environmental project issues. So this is something to pay attention to. This could be costly. So naturally, like everything else in the regulatory environment, paperwork is key. Preparation is important. If you have an OSHA inspection, the chances are that there'll be certain issues that are negotiable, and you obviously would like to have it result in a negotiated settlement rather than administrative hearings and litigation, for which the costs can definitely mount. So OSHA shows up at your facility. What do you do? There's a tendency to think naturally about, well, doesn't a regulator need a warrant? The OSHA Act, Section 8 of the OSHA Act, confers extremely broad powers on OSHA to inspect. A request for a warrant is generally an antagonistic way to start the encounter and futile. So let them in and notify appropriate personnel in your shop that OSHA has arrived and that they're there to conduct an inspection. And it is important to have an inspection plan. You do want to have appropriate management personnel assembled to help you escort the inspector and record the conduct of the inspection. A reasonable time to get your people together is generally an hour. It's really not unusual for a bit of logistical organization to occur when an OSHA inspector and a compliance officer show up. There may be several people. You generally want to have an equivalent number of your own managers and personnel to accompany and frankly sort of babysit the activities. A health and safety officer, production manager, your HR manager, these are the types of folks that you'd like to get involved. There's a number of different types of inspections. There's site-specific targeting, national emphasis, a whole host of ways in which your particular operations can be brought to the attention of OSHA. If the inspection falls under a category other than site-specific targeting, which is a wall-to-wall, full facility inspection, you want to think about narrowing the inspection and thinking about how to walk them through your facility in a way that you don't go unnecessarily into areas that aren't the subject of the inspection. So when you're waiting for folks to show up in your shop to accompany the inspectors, you want to be thinking about planning a route through your facility and making it as limited as possible. So let's say the inspection is the result of a complaint. I mean, when OSHA shows up, they're required to conduct an opening conference. And during that conference, that's an opportunity to ask a lot of questions. If it's an employee complaint that triggered the inspection, you are entitled to ask for and review the complaint, but you're not entitled to know who filed the complaint. Don't attempt to find out the identity of the employee, and under no circumstances should you attempt to discipline an employee for submitting a complaint to OSHA. Again, the whole objective in managing an OSHA inspection is to understand what it is they're interested in and what your potential alleged violations might be. So during the opening conference, take very copious notes. If there are requests for injury or illness logs, you are required to provide these as soon as possible, but in no event later than 4 hours. That is a regulatory requirement. If OSHA requests other records, I generally recommend that you inform the compliance officer that you'd like a written request for records so that you respond comprehensively and appropriately to them. That also buys you some time to get things put together. Don't produce documents other than the injury and illness logs that you're required to produce within the prescribed time period. This is something that is typically provided later. With respect to requests for example, industrial hygiene monitoring, such as air and noise sampling, let the compliance officer that you'll coordinate about logistics at a later date. Then you can work with your safety and insurance personnel so that the company can conduct the monitoring at the same time as OSHA, kind of like split sampling in the environmental context. If there are requests for interviews, confirm that they will occur. OSHA does have a right to interview your employees, but don't commit to times necessarily right off the bat until you've had a chance to look at your work schedules and your production schedules so that you can do this in a way that doesn't interfere with operations. What else should you do during an opening conference? Sometimes a compliance officer will ask you for the phone numbers, the home phone numbers of employees so that they can be contacted individually. If a compliance officer does this, politely advise that you'd be happy to arrange for a private on-site interview. That's a requirement that you allow that to occur. Section 8 of the 8A2 of the Act also authorizes this during regular working hours or at other reasonable times during the inspection. So there is some flexibility for interviews of employees. As I said before, you want to plan the route based on the scope of the inspection. If an employee is interviewed by OSHA, they do have the right to request counsel or other witnesses. But the employee's obligation to participate in the interview itself is voluntary on the employee's part. So unless a subpoena is issued to a specific person or employee, that's a voluntary interview between OSHA and the employee. Now, once the introductory conference is concluded and the walk-around inspection begins, stay with the inspector or inspectors at all time. And that may be you in combination with some of your other management staff. and basically mirror what's happening. If OSHA is taking pictures or videos, do exactly the same thing, at least to the best of your ability. If they have a video camera, video a particular aspect of your operations. If they're taking photographs, take a photograph from approximately the same position and same angle. If there are any measurements taken, take your own measurements. If a compliance officer, on the other hand, is just sort of eyeballing a particular situation and not taking actual measurements, I wouldn't suggest taking measurements until after the compliance officer has left the room, because you don't really want to give them any ideas. Another important consideration is the compliance officer is really not permitted to interfere with your normal operation. So under no circumstances should you allow that to occur. Of course, unless there's some obvious imminent serious health safety situation going on. For example, if OSHA says, hey, why don't you run through your startup shutdown on this particular machine, we'd like to see how that works. I think you should politely, and I recommend that you politely decline. Any requests that this be done for purposes of observation should be declined, because it's interfering with your operations, and OSHA really isn't entitled to do that. You can also postpone interviews if that would interfere with facility operations. Now, in a situation where a compliance officer asks you to make changes based upon observations during an inspection, you don't have any obligation to do that. If in your opinion, however, the suggestion could improve safety and would be cost effective, go ahead and do it, but it's useful to record what the condition was before the correction and what the condition was after. This can be accomplished through photographs. Which is the subject matter of the slide that I just went over. With respect to the employee interviews, again, OSHA is entitled to interview hourly employees in private unless the employee wants you to be there. The employee is also entitled to have a union representative present if desired. You can ask an employee later about the subject matter of the interview, but be careful to recognize that this is on a voluntary basis only. You should not pressure the employee to provide information, and that you should only have that conversation if the employee is comfortable and willing to do so. On the other hand, as opposed to interviews of your employees, if management and supervisors are interviewed by OSHA, you're entitled to have a management representative present. Sometimes these conversations lead to a compliance officer handing you a document to sign, maybe notes of the particular discussion or some other document. I recommend that you not sign them. These documents are not exact transcripts of what may have transpired. There could be errors in the documents. You're under no obligation to sign documents during an OSHA inspection, and it's not a good idea to do so. Attorneys can be present at meetings between OSHA and management and supervisory personnel. It's not essential. This is the sort of situation where you want to make the determination on a case-by-case basis. For example, if you had an unfortunate circumstance where there's been a fatality or a serious injury, or there's reasonably a significant exposure, that would possibly be an instance where you would want to have your regulatory attorney or OSHA attorney show up and accompany you and help to moderate the conversation. In all events, take notes, record the discussion. Sometimes an inspection runs longer than a day or 2 days or a week or a month. Depending upon the extent, and by the way, these inspections can run up to 6 months, depending on the circumstances and the complexity of the operations. Confirm the schedule with the compliance officer. When will the compliance officer return if he's leaving on a particular day? Ask for written confirmation of what OSHA wants from you in terms of documentation and when they want to return. Get a list of what employees OSHA wants to interview, if anyone. and if applicable, get specifics on any monitoring that OSHA intends to conduct, such as hygiene monitoring. You want to arrange for your own professionals and consultants and qualified personnel to conduct their own monitoring in the same fashion so that you have something to judge OSHA's determinations on. Finally, after the inspection has concluded, the compliance officer will conduct a closing conference with you. At the closing conference, the compliance officer will tell you what citations, if any, they are expected to issue. You're not entitled at that point to know what the potential penalties are or the severity of the violations in terms of how they're classified as, serious or other than serious or willful and the like. But you do generally leave a closing conference with an understanding of what it is the OSHA intends to do in terms of a future citation. If typically there are also discussions about abatement measures that you'll be required to take, steps that OSHA will direct you to do to correct alleged violations. Don't commit to anything at that point in order to maintain a degree of flexibility and to avoid making admissions of wrongdoing. And certainly don't make any predictions about how long it would take you to accomplish any abatement measures. So now that you have a pretty good idea on navigating an OSHA inspections, clearly you want to make sure that you have all of your appropriate paperwork in order, because that's quite often a focus of an inspection is record keeping. Make sure that your OSHA logs are complete and accurate. Make sure you have, an inspection plan that you designate people who would serve as part of a team. It used to be that there'd be inspection kits, and I know many facilities have them with cameras and video cameras inside. I suppose with the advent of smartphones, it's a little bit less of an issue in terms of taking photographs and videos, but it is useful to have the hardware there so that you can, in fact, take photographs and videos as needed. And then I guess lastly, you can reduce and should reduce sort of the game plan to writing so that appropriate management personnel, HR, health and safety personnel know what's expected when OSHA shows up. Now, quite often there's this idea that a compliance officer is there to help you. He or she establishes a rapport during the conduct of the inspection. Things get conversational. Perhaps assurances are made, at least informal assurances from the compliance officer that things aren't too bad and everything's going to be okay. But the fact of the matter is their role is to collect information and evidence. Their compliance officer's role is to record conditions at your facility, which ultimately will be conveyed to an area director. OSHA has regions throughout the country. We're in Region 2. There are numerous area offices in various cities throughout New York State. And in the boroughs, the area director ultimately will be the one to consider recommendations by a compliance officer and could very well overrule a compliance officer's determination based upon the record. Another misconception is that you shouldn't aggravate the compliance officer or area director by contesting or using a lawyer. This is extremely common and typical to get legal counsel involved. What you don't want to do is send a signal to OSHA that you're going to roll over every time they come into your facility, particularly since, again, that could expose you to very significant repeat or willful violation penalties later on down the road. OSHA citations can be a cost of doing business, but it is not a situation where, for example, an initial minor OSHA penalty is something that you shouldn't be concerned about. It's sort of like a Trojan horse. If they come into your facility and find, for example, that there's a irregularity with a machine guard or a ladder position or some other regulatory violation that results in a moderate civil penalty, if they come back in again with, in the wake of a settlement agreement or a consent order, after which you've already been cited for that particular type of violation, the costs go way up. So that's definitely something that you want to plan for. So what's a citation? Some of you may have been unfortunate enough to receive one. It's generally, as you can imagine, a very detailed description of a particular regulation, how it applies to your operations, and how it was violated. This citation will also indicate the severity of the alleged violation and penalty proposed. There'll also often be corresponding abatement items with a schedule, a compliance schedule for dates you have to meet to correct the alleged violation. Unless you accept the citation and you don't contest it, these initial abatement dates are not enforceable. Now, generally, well, in all instances, you have 15 working days from receipt of a citation to schedule an informal conference, and if necessary, to contest the citation. If you elect to have an informal conference, have it with the area director if possible, as opposed to one of the compliance officers. This is an important point and an important decision-making point for you once you receive a citation. 15 days is not a long period of time. If the citation is detailed and complex, or if there are issues that require certain personnel who may not be available to adequately assess, or third-party consultants to engage in conversation and assessment of alleged violations, 15 working days is a blink of an eye. And the reason it's an important window is OSHA will try to get you and encourage you to enter into an informal settlement. The problem with that is that that is tantamount to a final order and determination of a violation, which would then form the basis for a repeat violation at a subsequent date. So my recommendation and advice to clients who have received an OSHA citation is, if you're in doubt whatsoever about whether alleged violations are legitimate and based in fact and for which you have no defenses, unless that is painfully crystal clear, and also unless there's a very unlikely probability of this violation ever being brought to bear again in a future citation, contest it. Contest all citations, really, unless, as a default strategy, unless there are other circumstances that would dictate otherwise. There's two types of settlement agreements, as I said before. There's an informal settlement agreement, followed by if you do contest within the 15-day period, and that can take the form of a letter written by you or your legal counsel to OSHA indicating that this is a notice of contest with respect to a specified citation. If you do contest the citation, what then ensues is a more formal process that would lead to the negotiation of a consent agreement and final order, a CAFO. Both an informal settlement agreement and a CAFO can form the basis for a repeat violation in the future. But in the latter context, when you've had more than 15 days to consider an alleged violation, you've got a lot more time and you can put a lot more care and consideration into how to respond to it. By contesting a citation, you are not forfeiting your ability to continue settlement discussions with the area director. So there, and another way of putting it, there doesn't seem to be any significant downsides to submitting a notice of contest. There is a significant downside, however, to not submitting a notice of contest, because again, you're basically waiving your right to challenge any alleged violation, and therefore those violations will form the basis for a repeat violation in the future. So let's say you take that advice and you submit a notice of contest. The file is then transmitted to the regional solicitor of the Department of Labor. These are OSHA's lawyers. Sounds kind of intimidating. Under the regulations, the solicitor is required to file a complaint within 20 days of your notice of contest. That then starts a whole process of putting the case on a docket before an administrative law judge. But as I said before, in most instances, the area director, as opposed to the OSHA lawyer, will continue to engage in settlement discussions with you, and frankly, a 20-day period for filing the complaint can be extended by mutual consent. And even if there isn't mutual consent, failure for the regional solicitor to file the complaint is not fatal to the enforcement action. So again, filing a notice of contest is not really a huge deal in terms of, it doesn't lock you into litigation mode. It just, in most cases, buys you more time. Certainly, if the subsequent settlement discussions are not productive and don't go the way you want, you can and should proceed to proceeding before an administrative law judge. That whole topic is beyond the scope of today's presentation. If the ALJ determination is adverse to that, is subject to review and ultimately in federal court. So I'm not really going to dwell on any of that, nor am I going to get into too much detail about defenses. But generally speaking, when you look at alleged OSHA violations, you've got three considerations. Is what OSHA is telling you you should have done or are required to do a violation? Is it technologically feasible or possible? Is it economically feasible? Would taking a different approach actually result in a greater hazard than how your particular operations are being conducted now? Lastly, and this is kind of a long shot, is the fact that, in some instances, a violation could be the product of employee misconduct. This is very difficult to prove, and it requires a history of disciplinary action for workplace infractions, which is often really not the case. So that sort of is the whirlwind tour of managing the logistics of an inspection and responding to a citation through either an informal conference with an area director or, in many cases, more formal settlement discussions, filing a notice of contest. I'm now going to move into sort of an area of a new regulatory development. In 2016, new standards were issued under Subpart D, which address walking, working surfaces, and personal fall protection. The reason OSHA did this is because fall injuries are one of the most common injuries in the workplace, and one of the most leading causes of serious work-related injuries and deaths. You can see from the statistics here that OSHA estimates that 20% of all disabling occupational injuries result from falls. 15 of accidental deaths, 15% are attributable to slip and trip and fall incidents. OSHA estimates that this new rule will prevent 29 fatalities and roughly 5,800 lost workday injuries each year. So there is an economic component to this as well. So effective January 17th, this new rule updated a 45-year-old general industry standard. It adds a new section under the general industry personal protective equipment standards in Subpart I as well. Subpart I establishes detailed requirements for personal fall protection systems. I'll get into that in a moment in a little bit more detail. Applicability. This new rule applies to all general industry workplaces unless you're explicitly excluded. So, the chances are that most, if not everyone listening in on this presentation is affected. I see now that a question came in. I'm sorry I missed that before. It looks like quite a few came in, and I apologize that I missed it. One of the questions is whether a copy of the presentation will be made available, and the answer is yes. Some of the other questions I think would probably be better answered directly via email, so I think I'll just sort of put that on hold depending on how much time we have later. Sorry for the digression there for a moment. So getting back to what it is that we're talking about right now, the applicability is broad. However, it does not affect the construction or agricultural industry standards. So what are the benefits to you as an employer? As I said before, it's estimated that this is going to prevent lost workday injuries every year. It also allows greater flexibility for you to choose a fall protection system. And for example, it eliminates the existing mandate to use a guardrail as a primary fall protection method. Now, fall protection and guardrails deals with situations with unprotected sides or edges. This is generally defined as a edge that's at least 4 feet above lower level. A fall protection system is broadly defined as any equipment, device, or system that prevents a worker from falling from an elevation or mitigates the effect of a fall. So it's a far-reaching definition. The flexibility for fall protection systems, again, moves away from a mandatory guardrail to also include safety net systems, personal fall arrest systems such as body harnesses with anchorages and connectors, but not body belts. Body belts are now no longer an acceptable personal fall protection system in and of themselves, such as belts with D-rings. And this is really carries over from the construction standard. There's an attempt here to align the general industry with the construction standards when it comes to fall protection. Travel restraint systems that allow hands-free work, for example, on windowsills, are another option. Ladder safety systems, such as those incorporating a carrier and a safety sleeve and a lanyard and a body harness, are one of the available options. Conversely, cages and wells are being phased out and are no longer going to be acceptable, at least according to a compliance schedule set in the new rule, which I'll get into in a minute. The new rule also phases out the 1993 exception for outdoor advertising industry. That allowed so-called qualified climbers to forego fall protection. The problem is that that particular exemption unfortunately resulted in some serious injuries and 1 fatality. So in the advertising industry, there's no longer a qualified climber exception. So this is what the new Subpart D looks like in terms of its scope. You've got you've got general requirements that I'll outline in a moment, coupled with specific provisions and a whole host of detailed specifications and definitions for ladders and stairways and dock boards and scaffolds and rope descent systems. This is a broader, more consolidated scope. It used to be you had to go and check out separate sections of the rule to determine whether a specific piece of equipment was covered. This hopefully will enhance the clarity of applicability issues. Again, this applies to all general industry workplace unless it's specifically excluded. Step bolts, of course, are bolts or rungs attached along a structural member used for foot placement. Manhole steps are those that are attached to a wall of a manhole structure. Dock boards, for example, are portable or fixed devices that span a gap or compensate for a difference in elevation between a loading platform and transport vehicle. And the list goes on and on. There's lots and lots of definitions in these regulations. So here's kind of a basic overview of how this whole program works. Generally speaking, it requires you to identify and evaluate slip, trip, and fall hazards in your facility. It requires you to provide appropriate personal protective equipment. It requires regular and periodic inspections, and it requires you to maintain all walking and working surfaces in a safe condition and train those affected. I mean, that's sort of a very broad stroke description of what the new rule covers. I searched the new regulation for the word record keeping, or document, or log, or other terms that would, suggest a very specific type or frequency of record keeping requirements, and there are none. So really, the degree of record keeping and paperwork you will need to maintain will be operation and site specific, but you do need to, in all instances, record what it is you're doing to demonstrate compliance. Otherwise, if you have an OSHA inspection, you'll be at a loss for doing so. In terms of the surfaces that are covered, all horizontal, vertical, or inclined walking, working surfaces, there's a list of examples there before you. As I said before, there's an extended compliance schedule that will allow employers more time to implement larger scale capital expenditures like retrofitting existing ladders and enhancing fall protection. So here are the general requirements for surface conditions. Keep them clean and orderly. Make sure there aren't any sharp objects, spills, snow, or ice. You know, the inspections you can see in the middle of the screen should be conducted regularly and as necessary. So again, this is going to vary, but you know, I guess I would suggest that depending on your resources and personnel, you know, weekly certainly wouldn't necessarily be too often. I think if you don't inspect on more than a, say, monthly basis, that might start to raise some questions. So it's really a judgment call, and it really depends on seasonal issues also, obviously with respect to snow and ice and weather-related conditions. You have a requirement to correct and repair hazardous conditions before you reuse them. So for example, you can't have a ladder missing a rung and then having it leaning against the wall. You need to take it out of commission and repair it before it can be put back into you know, general circulation of available equipment. When you have to do a repair that involves structural integrity, you have to use a qualified person as defined in the regulation specified there. So here's the compliance timeline. I've tried to put this into a kind of a easy to follow chart. The font is so small, frankly, I can't even read it from where I'm standing, and I'm standing pretty close to the screen. But it's by way of sort of perspective, falls from ladders, again, are 20% of all fatal and lost workday injuries in the general industry. So this is a primary focus of this regulation. Ladders must be inspected before initial use in a work shift. So you have to inspect the ladder before each work shift, and I advise you to document that and identify any defects that can cause injury. This new regulation phases in a requirement for employers to have a ladder safety or personal fall arrest system for fixed ladders that extend more than 24 feet. So this is the 24-foot ladder applicability program. The regs phase out the use of cages or wells for fall protection under the timeline set forth above. So in 2 years, all new fixed ladders and replacement ladders and ladder sections must have a ladder safety or personal fall protection system, as those terms are defined in the regulations. For existing ladders within 2 years, you have to install a cage, well, ladder safety system, or personal fall arrest system on fixed ladders that don't have any fall protection. And finally, within 20 years, which seems like a long way off, all ladders extending more than 24 feet must have a ladder safety net or personal fall arrest system. So ultimately, 20 years from now, cages and wells are phased out. There are definitions for fixed ladders, portable ladders, mobile ladder stands and platforms, rope descent systems. With respect to rope descent systems, the new subpart D codifies the 1991 OSHA memo allowing their use, but it adds a 300-foot height limit. And in those instances, you have to certify that the permanent building anchorages have been tested and are capable of supporting 5,000 pounds for each worker attached. Now, all of the requirements I talked about with respect to inspecting work surfaces and the safety of work surfaces generally are in effect now. So the records with respect to those types of inspections and requirements you should be maintaining now. A little bit more concrete example of an obligation for which records should, for which you should have records is the training requirement that was due May 17th of this year. And this is the training of workers who use personal fall protection and work in a high hazard situation. The training should be conducted by a qualified person and cover use of the equipment such as those specified here. And you have to retrain in response to changes in facility operations and or where an employee, I guess, messes up, and that comes to your attention and requires an opportunity for retraining on a particular skill. With respect to what constitutes a qualified training person, that's a little bit flexible. A person who, by possession of a recognized degree, certificate, or professional standing, or who by extensive knowledge, training, experience has successfully demonstrated the ability to deal with these types of situations. So it can be somebody in your employment who, through professional experience, knows what he or she is talking about. The training has to be provided in easily understandable language, and obviously, if a person doesn't understand a particular language or vocabulary, you have to make adjustments there. You can also look for technical guidance on training on OSHA's website. There's an easily navigable OSHA website that has a working surfaces section that you can refer to. The new rule also talks about or specifies falling object protection criteria and practices in section 1910.29. Each one of these systems has to meet very specific specifications for guardrail systems, safety nets, designated areas, and so on. There are special training and requirements for outdoor advertising that I alluded to before in 1910.29H. There are specific standards for ladder safety systems in the regulation indicated there. So a lot of detail, and very much the applicability of this will depend on what you have at your own particular facility. Now this particular slide deals with personal fall protection systems, and it's outside of subpart D. This is in subpart I in 1910.140. I won't spend really much time on this. It's got extremely detailed performance criteria. I would suggest that you refer to the regulations to assess whether any of this is of concern. The training and use is subject to very stringent standards. Qualified people have to inspect every knot in a lanyard or vertical lifeline, for example. And personal fall protection systems cannot be used for any purpose other than fall protection. You can't use a PFPS for hoisting equipment on site, for example. So, like everything else, it's important to inspect regularly and as appropriate, to document those inspections, to keep your workplace safe by keeping the floors clean and dry, provide appropriate and compliant personal protective equipment at no cost to the workers, and try to engineer out hazards where possible to not only minimize the exposure to liability, but to minimize injury to your workers and loss of work days. Document and comply is the mantra of the day. So that brings me pretty much to the end of my presentation. I'm going to now refer back to the questions, one of which is, if an employee verbally reports that he had, for example, a twinge in his shoulder but does not seek medical attention, several months later he or she says that the twinge has continued to bother him and he wants to see a doctor, the doctor takes him out of work or gives him a prescription, what date is used on the OSHA log, the original verbal report, or the date that this becomes OSHA recordable? But that's an interesting question. I mean, all OSHA injury and illnesses are reportable if they are work-related. I would say that, the conservative answer is that you report as of the earliest possible date, but I think I need to know a little bit more facts to give you any sort of a definitive conclusion, and I'm not intending to do so now. This is a general overview presentation, so if you need specific legal advice, I think we'd have to have that conversation offline. There's another question of whether OSHA can obtain copies of any photos and videos taken by an employer during the inspection. They could do so in the context of, yes, I mean, they have very broad investigatory powers. I mean, in some instances, you would be sort of generating evidence or data at the request of legal counsel, and therefore there could be a potential attorney-client privilege issue. But those sorts of determinations are always sort of susceptible to different opinions. So again, it would depend upon the manner in which the photos were taken, but I think as a kind of conservative, practical matter, you should assume that any photos or videos that you take can and would be produced to OSHA in the context of litigation and discovery. So I hope that is useful. I thank you for participating. I had some technical issues at the beginning, so I apologize if I was a little bit disjointed, but thank you again for joining. And don't, let me return to our last slide here. Don't forget to sign up for tomorrow's presentation at the website shown there. Tomorrow we're going to have a presentation by Caroline Westover, and she will be discussing immigration issues such as I-9 employment eligibility, work visas, and Trump administrative developments. So thanks again for joining us, and we look forward to your joining the presentation tomorrow. Good day.